U.S. District Judge Shira Shinlin recently said in a written ruling that there was overwhelming evidence that the centralized stop and frisk program led to thousands of unlawful stops. She noted that the vast majority of New Yorkers who are unlawfully stopped will never file a lawsuit in response. And she said class action status was created for just these kinds of court cases. Mr. Darius Charney, the Center for Constitutional Rights attorney litigating the case, will inform us about what this means for possible victims. Thank you for joining me today, Mr. Charney.
No problem. Thank you for having me.
Oh, you're welcome. For those who are unaware or do not exactly know what stop and frisk is, can you briefly educate them about it?
Sure. When we use the term stop and frisk or stop, question, and frisk, what we're talking about is basically when a police officer or some other kind of law enforcement officer, briefly detains somebody, deprives them of their liberty, whether it be, stopping them on the street or even, stopping them while they're in their car, and then, asking them questions, and then frisking them, which basically means, patting down the outside of somebody's clothing, which the police are only permitted to do in situations where they reasonably suspect that somebody has a weapon on them. So that's what we mean when we say stop, question, and frisk.
Now, I know from reading that this case arose out of a 2008 lawsuit. For the uneducated or uninformed, what is the significance of Judge Shinlin's ruling?
Well, the significance is that, and I think it was in the words that you read from the decision a moment ago, that, because the case is a class action, it allows for, the hundreds of thousands of people who otherwise would probably not have the ability to bring their own lawsuit to participate as plaintiffs in this case if they have been illegally stopped and frisked by New York City police officers.
So are you saying they may be financially prohibited from bringing a suit?
Well, no, what I was, saying is it obviously it takes a lot of time and resources to go out and hire your own lawyer. If you've been, stopped and you feel you've been illegally stopped, to sue, you got to find yourself a lawyer to take the case, which, oftentimes takes a lot of time and resources to do that. And, the thing about individual stops and frisks is, on an individual basis, it's hard to recover a lot of money from one stop and frisk because, most of them don't last very long. It doesn't usually involve an arrest and, usually, fortunately, it doesn't involve, an officer using force on somebody. So in terms of the financial compensation that a lawyer would be looking to get for taking an individual case, it probably wouldn't be very much money. So that's why it's difficult, I think, for folks to go out and find a lawyer to bring one of these cases for them as an individual. So to have a class action where everybody is automatically part of the plaintiff class if they've been illegally stopped and frisked, I think is a beneficial thing for, thousands of New Yorkers who otherwise wouldn't have the ability to, have their day in court.
Now, can you give us a more technical definition of who might be a victim? Because from what I've read, it could be hundreds of thousands of them. So
Yes.
what has to have had occurred for them to potentially join this class action lawsuit?
Well, if they were, stopped and or frisked by New York City police officers in New York City between January 31st, 2005 and the present, and they were stopped without reasonable suspicion that they were engaging in, a crime, and or they were stopped on the basis of their race, then they would be a member of the plaintiff class in this case. So, anybody out there who, has been stopped by New York police over the past, I guess that would be seven years, who feels that the police didn't really have any basis to stop them, could be a member of the class, and we would encourage them to contact us. We actually have a website for class members if people are interested. It's www.stopandfrisklawsuit.com, and you can, fill out an online questionnaire, which, would give details about your stop. And the only people that would see that information would be the lawyers in the case. It's privileged information, so, your privacy would be protected. But, if you're interested in getting involved, that's a way that you could do that.
Could you get a website one more time, please?
Sure. It's www.stopandfrisklawsuit, it's all one word, .com.
One last question. In reading about the responses from the city of New York, attorneys said in one of their responses is that if the policy was unlawful or unconstitutional, the state legislature would have done something to stop it. To me, that sounds like a confession and in the very least a weak response. What do you think about it?
I think, you're absolutely right. And I think the other thing it suggests is that they don't really have any respect for the fact that, the federal courts are specifically empowered and expected to uphold the constitutional rights of people. So to basically tell the court, like, look, stay out of this, this is the legislature's business to fix it, is really, I think, disrespectful and dismissive to the judicial branch of government. But I think more directly to your point, I think one of the things that the city of New York is missing here is that, you can have all the laws you want on the books that say, we shall not stop people illegally, we shall not racially profile, and that's all good and well. But the problem is when it comes down to what the police department's actually doing on the streets every day and the way that they're enforcing the law is illegal. And no legislation that would pass would prevent that. It's up to the police department to change its practices, and if they won't change them, we're going to get a federal court to make them change them. So that's, really our response to that argument that they're making.
In closing, is there anything in general about Stop and Frisk that you want our listeners to think about?
I think, you hear a lot from the pro NYPD side about how, they try to create this false choice between, safety, security on one hand and liberty and fundamental constitutional rights on the other hand. And I think that's a very false dichotomy. In other words, I don't think those two things are inconsistent with each other. I don't think they're mutually exclusive. In fact, I would say that it behooves all of us and it actually promotes public safety for the police department to, respect people's constitutional rights and police the streets legally and constitutionally. Because if they don't do that, it's, then the democracy that they're supposed to be protecting is going to disappear, and it also is going to create a lot of tension between the communities that are being policed and the police themselves, which I think then makes crime fighting more difficult. So I think that it's good for public safety to have the police respect people's constitutional rights.
Thank you for speaking with me today, Mr. Charney.
No problem. Thank you for having me.